morning, everyone. I'm very happy to be here doing one of the keynotes at this year's LexTalk, and that too in person. I thank you all for being here. It certainly makes for a different kind of experience to be here in person, although I know there are many people virtually who are tuned in as well. And I thank LexTalk for providing us with this platform. I will try and keep this under 20 minutes. I will use a slightly different format, more of a narrative and very little kind of when it comes to slides. So I am here to speak about risk today. And, all of us, I think, here have taken a risk by being here. We know that the pandemic is still raging in some parts of the world. There is also a war out there. So risk is part and parcel of everyday life. And I think everyone, everywhere, manages it in some way, shape, or form. But since we are in a formal setup here, we will go a little bit into how we define it, how we handle it, and things like that. So what is risk? According to a French philosopher, Francois Eval, nothing is a risk in itself. There is no risk in reality. But on the other hand, everything can be a risk. It depends on how one analyzes the danger or considers the event. So I think it's all about perspective and perception. But in the corporate world, we have created a reality for risk. It is something we measure, we manage, we fear, we preempt, and many a times we do pay the price for. There's another analogy that really interested me when I came across, and I thought it was relevant. This is from mountaineer and US Senator Mark Udall. It's about climbing mountains. He says, you don't climb mountains without a team. You don't climb mountains without being fit. You don't climb mountains without being prepared. And you don't climb mountains without balancing the risk and reward. And you certainly don't climb a mountain on accident. It has to be intentional. And I think managing risk in organizations is pretty much like this. It has to be planned, intentional, and deliberate. So at a broad level, as I said, managing risk is what I'm going to be speaking about, of course, with a focus on employment law. And as my colleagues Aditya and Priya said, we are a labor and employment law firm and have been entrenched in labor and employment laws for the past 6 decades. So I hope I can share some of those learnings with you. At a personal level, labor and employment laws is not alien to me. It's much more familiar than it would have been had it been an area of specialization or just a career. My father is actually the doyen of labor laws in India, and growing up, this is all I heard every single day, and now I am entrenched in it as well, and I also deal with it every single day. So diving in, let me start with an example of employment risk gone bad. Just imagine you are a global, your company or a multinational, you've just entered India, and very soon, a few months into your operations, your board of directors actually receive criminal summons on just because they have failed to issue employment orders in the required format to certain employees in India. Now, this actually happened to a pharma major not too many years ago. So clearly an example of risk gone bad. But what happened? What was the failing? It was just simple mismanagement of a known compliance that they could have easily prevented. It was just issuing it in a certain format. But because for even small lapses in compliance in India, the board and the management is held liable and culpable, these people had to receive criminal summons. Personally, for me, my risk management journey actually began 20 years ago when I was still living in the US and the big Enron crisis happened. Our entire industry had to comply with Sarbanes-Oxley, and I was in the thick of implementing it for my organization at that time. Now, risk management has certainly evolved since then, and I think the whole global ecosystem is more aware and proactive, like how Gaurav was just showing, very elaborate compliance programs within organizations today. But when it comes to labor and employment laws, we feel that it is not addressed as much as tax or finance or corporate laws. Yet it has very real implications. It has the potential to create equally significant damages and invariably leads to reputational loss. That's why we call it an insufficiently addressed risk. It is addressed, but is it accorded the same importance is the question. For instance, there are many law firms here today. We have people from various geographies. Now, tell me how many law firms have large employment law practices, although it is an everyday necessity for every organization. Now, within organizations as well, who manages labor and employment law risk? As far as we have seen, it's typically the HR function in the organization. It is their duty. But even then, it's just one of the many things that HR does, apart from recruitment and performance management and various other things. Industrial relations and employment relations is only one of the many responsibilities that is shouldered by the HR. And the consequences of not managing issues adequately in this area has staggering implications, operationally, legally, and financially. The risk exposure is fairly high. For example, let's take retrenchment. I'm going to quote an example from India. There are very clear guidelines laid down by the courts in India on the termination of workmen. Yet there are close to 500 reported judgments and actually close to 50,000 cases that have been settled outside court, where both large public and private companies have failed to follow the law of retrenchment and have had to end up reinstating workmen and pay back wages. Another recent incident in India is that of a large iPhone manufacturer. In this company, vendors flouted overtime rules, and it resulted in about 3 months of lost production and millions of dollars worth of damage. It made for a lot of bad press. And in both these instances, it was just simple failure to follow the due process. So what does employment risk actually entail? According to me, there are two parts. One part that is statutory and regulatory, that is driven typically by documents. And the second part are all the legal procedures that are mostly managed through policies and processes. And for both of this, we need process, methodology, and technology. Now, we at BCP Associates manage risk for large organizations and have been doing so for the past couple of decades through employment law audits that are part of larger enterprise risk management programs. This is replete with process, methodology, technology, and the law. And I think this type of well-roundedness is an imperative. Risk management is deeply driven by tech today. I'm sure most of us here know that. It has been so for some years now, but just going by the staggering amounts of data that is out there that Gaurav just indicated, this is an absolute must. And going forward, tech is only going to increase. The likes of blockchain, artificial intelligence, machine learning, big data, analytics, all these are going to be an integral and default part of any risk management technology. But when we started back then, there were very few takers. So I want to share an anecdote with you. This is when I had just moved back from the US to India and started one of these programs. This was a large BFSI or financial services company headquartered in the US, has its captive unit in India. They had engaged with us to actually roll out this program. And it was the day of the launch. We had all the stakeholders in the room. We had the heads of all various functions, whether it was HR, admin, compliance, finance, legal. Everyone was there. And after a brief introduction of the program by the legal head and the CFO, I took over the stage and I started taking people through this entire program. What are the nuances? What is it end to end essentially? And all I saw across the room was like a sea of blank faces. Nothing registered, and some people even had expressions of incredulity on their faces. So in the break, I just struck up conversations with a few people just to get a feel of the pulse. And a few of them came up to me and they said, so much of structure for employment laws. They said it's a very complex area. And do you really think something like this is going to work? Something so complex and convoluted, can it be so structured? And they promised me that it may not see the light of day. And even if it sees the light of day, it's going to be very short-lived. But let me tell you, it's 8 or 9 years since, and this program has run incredibly successfully. Every leadership regime that has come has continued to run it. They are at very high compliance levels and they have been able to sustain it. Why? Because the solution had the right mix of law and technology. More importantly, the right level of human discretion and intervention. As much as we have technology, it has to be a mix of, the minds of people like us who apply it both practically and from a legal standpoint to ensure that whatever we are measuring, whatever we are tracking, whatever we are finding out, what are the gaps, how do we mitigate that? So it is that right mix of both of it, which I think lends itself to success. So statutory compliance is one area. Another area that is weak in employment laws, which most of you may know, is employment contracts. We see this far too many times on a day-to-day basis with various companies. There is insufficient importance accorded to employment contracts, and we see instances where companies are unable to terminate without notice, or there's too much notice, no probation, non solicit violations, and the like. Now, this is also an easily addressable area that can be strengthened. In fact, many cases of disparagement and other deviations can be managed if employment contracts are structured better and drafted the right way. In Asian countries, that's just an example I took, if you look at employment-related non-compliances, the volume is pretty compelling. For instance, removal from service is one of the most regulated areas, and it comes with considerable penalty and significant enforcement, yet it is one of the most commonly flouted provisions despite the risk. There are several specific examples in Philippines, Vietnam, and many other Asian countries. This is true in geographies like the US, UK, and Europe as well. So how can employment risk be managed? Again, I think there are two dimensions. It's one is the organizational behavior, and the other is employee behavior. At the organizational level, of course, we know it is the culture and values and DNA of the company. Now, today, GRC, or governance, risk, and compliance, is in quite a mature state, and ESG has entered the global scene. So ESG, or environment, social, and governance compliance, is the moral obligation on companies to increase social and environmental good. And a significant portion of the S in ESG is all about managing your employees and their employment, and of course, everything down through the supply chain as well. So from an organization risk management perspective, the pertinent questions are, is the organization managing its statutory compliances adequately and satisfactorily? Much like the model that we saw that Gaurav just presented from Landmark, of course, in data protection context, but fundamentally it is the same. You can apply it to any different area. Here I'm talking about employment laws. Are the right policies in place? Are disciplinary measures in place? How formal are the employee life cycle processes, right from recruitment to retrenchment? And do they incorporate the absolute critical mass of applicable employment laws? Now, of course, we know the company will have to follow the law both in letter and spirit, but what is important is balancing it against its business operations so that it is practical. Many a times we see that the law is sometimes impractical or absurd, but we don't have a choice. We have to comply. And a lot of times we see companies taking a calculated business risk and saying that, okay, I'm going to comply with this, but these are some of the exceptions. Now, if you take that route, then you must be fully acquainted with what the risk is and what its mitigation needs to be. So being fully aware of the consequences before making a decision to, comply or kind of comply to a certain extent, which may be practical for you, again depending on the enforcement scenario. Now, when we talk about taking a calculated risk or taking risk itself, one of the other issues that we commonly see in companies is the confusion that prevails around local versus global policies. Now, let's say it's a multinational company. You have a lot of global mandates, your internal company policies, and you also have your country level policies. Now, this confusion we see happening frequently in the area of sexual harassment, one of the areas that we also deal with. Organizations are not sure whether to investigate these sexual harassment issues on the basis of the global company mandate or the local procedure. Of course, it is imperative that you absolutely follow the law of the land, and only if a global policy incorporates this required threshold and goes above and beyond the law of the land, what is permissible in that jurisdiction, only then will the global policy prevail. Otherwise, you must go with what the local policy says. So all this was at the organizational level. Now, how does this translate at the employee level? At the employee level, education and awareness is key. And for any risk management to succeed, the tone needs to be set at the top, communicated widely, and the organization must have its ear to the ground to understand what's going on at the grassroots level in the organization. Now, issues like improper conduct, harassment, theft of confidential information, etc., are addressed well through policies, but there are many deviations that lead to significant risk exposure and has staggering consequences. Business loss, employee attrition, exposure of IP, loss of reputation leading to stock market crash, as we've seen that, financial damages, litigation spend, and things like that. So all in all, it is critical that employment-related issues are accorded the right level of importance at all levels within the organization, starting at the board level. I feel it needs to have the same place at the table as any other issue, tax or corporate or finance. So if the management and the board use a uniform lens, a lot of employment issues can certainly be preempted. I would now like to shift focus to what is coming, at least in India, which has global ramifications. So when it comes to India, we are at the doorstep of sweeping labor reforms. Many of you in this room may know, some of you may not know, something that the country has waited for decades. The regulatory regime is actually going through a transformation, and India is poised to catapult into the future of business. As many of you know, India is on a heightened growth trajectory, and many businesses are set to enter the Indian market. Many more businesses are being born every single day due to the startup boom, and mature startups are rapidly becoming unicorns. In fact, 100 unicorns have been created just in the last 14 months. That has been the rate of growth. So the timing of the reforms cannot be better than now. In India, 44 archaic labor laws are being subsumed into 4 new labor codes, and the objective of these codes are simplification, ease of compliance, digitization, and bringing employers and employees on an equal footing. Digitization, transparency, and compliance, as I said, are at the core of this new game plan, which will also actually ensure ease and speed of enforcement. The codes are set to increase penalties 100-fold with increased probability of prosecution. Now, the government, by going the route of digitization, what it has done is it will accelerate or increase the risk velocity, making managing employment risks even more critical than ever before. We may not have the time to take our own pace to comply with it because enforcement is going to be much faster simply because of digitization. Therefore, what should companies in India look out for? This labor and employment law revamp is going to have huge implications and impact on all the operations and functions in the organization. Wages are being restructured, so everything from wages to policies to contract labor and beyond. Now, we have been working with companies that have been in the thick of helping organizations prepare, and it is pretty apparent that only those who are proactive will be able to come out strong on the other side. Immediate action is a non-negotiable priority. It may be late if you wait for the codes to come. Much again, like what Gaurav said, they have put the entire framework in place, so when it comes, they will be able to comply. And finally, I certainly want to mention gig and platform workers. Globally, the emergence of this trend has been quite disruptive, including the remote work and hybrid work model. So this brings a new dimension and impact to employment risk. Figuring out and addressing the underlying risks that are inherent in these models is truly the need of the hour. For instance, the new labor codes in India have formally recognized and provisioned for gig and platform workers. So careful integration of these new models of work into the overall employment risk management strategy, both at the organization and government levels, is quite vital at this juncture. So to conclude, if you are in an environment where employment risks are not addressed the way it should be, a logical and immediate next step will be to reorient from vulnerability to resilience. Strengthen the base through clear understanding and evaluation of the risk appetite, risk behavior, and safety climate in the organization. In risk management, there are both formal and informal structures. Formal through GRC framework, where you keep risk management smart by creating risk data infrastructures and good reporting mechanisms. But informal, which I also think is quite important, is where the chatter and narratives going on throughout the organization are brought into the fold of risk management through open channels of two-way communication. This is because everything can look great on paper and in dashboards, as we know, but the reality on the ground could be quite different. So if we can merge both the formal and the informal, it will certainly be much more beneficial to any risk management program. Finally, it's all about establishing the right risk leadership, and perhaps one that is dedicated to the area of employment, but integrated with the organization's overall risk management strategy and philosophy. So, with the labor reforms in India and changes in other countries going on in other spheres, combined with the global ESG momentum, I think the cornerstones of success for most businesses will be transparency, ethics, compliance, and preemption. The right combination of legal and technology is a must, which will undoubtedly pave the way for success for managing employment risk. So, to end, I think the mantra for success is preemption, preemption, and preemption. Thank you. I also want to add, we have actually had the opportunity to compile a book of knowledge papers on labor laws. So I'd invite you to pick it up from a desk which is there in the back of the hall. Thank you.